Hello, good evening everyone. Welcome to another video with Pratham Test Prep, and this is your host Sushila Chaudhary. And in today's video we are going to be discussing all the bills that have been passed during the monsoon session of 2023. So the session which took place from July 20 to August 11 is a busy one, as there are 31 bills that are being tabled and discussed. Out of these 31 bills, 21 bills are new, while 10 were amendments of existing law. So the summoning of this particular, in general, if we know, there are three sessions that are held in the parliament. That is, one is budget session, the second is monsoon session, and the third is the winter session. Now these sessions, they are convened by the government, and the summoning power of the parliament is specified in Article 85 of the Constitution of India. So like many other articles that we have today, it is based on the provision of the Government of India Act 1935. This provision specified that the central legislature had to be summoned to meet at least once a year, and not more than 12 years could elapse between two sessions. Dr. B.R. Ambedkar stated during the Constituent Assembly discussions, stated that the purpose of this provision was to summon the legislature only to collect revenue, and that once a year meeting was designed to avoid scrutiny of the government by the legislature. His drafting of this provision reduced the gap between the sessions to 6 months, and specified that the parliament should hold at least twice a year. He argued that the clause as it stands does not prevent the legislature from being summoned more often than what has been provided for in the clause itself. Alright, so during the debate, members of the Constituent Assembly highlighted three main issues. One was number of sessions in a year, secondly, number of days of sitting, and who should have the power to convene the parliament. In these particular debates, Professor K.T. Shah from Bihar was of the opinion that the parliament should sit throughout the year with breaks in between. Others wanted parliaments to sit for longer durations, and gave examples of the British and American legislatures, which during that time were meeting for more than 100 days in a year. Professor Shah also wanted the presiding officers of the two houses to be empowered to convene the parliament in certain circumstances, but these suggestions were not taken by Dr. Ambedkar. Now, talking about the current monsoon sessions, there are some significant bills that have been introduced. I'll need to name a few. There is Forest Conservation Amendment Bill, which seeks to strengthen the protection of forest in India. Then there is Biological Diversity Amendment Bill, which aims to improve the conservation of sustainable use of biological resources of India. Then there is Revealing and Amending Bill, which is gonna repeal 30 obsolete laws. Then there is Jan Vishwas Amendment to Provisions Bill, which seeks to increase the transparency and accountability of the government. And there is obviously the Mediation Bill, which provides a framework for mediation as an alternative to litigation. Now let's see all these amendments by themselves individually, and let's dive a little deeper. So we'll start with Jan Vishwas Amendment of Provisions Bill 2022. Now this bill was introduced in Lok Sabha on December 22nd, 2022, and it amends 42 acts to reduce the compliance burden on individuals and businesses to ensure ease of doing business. Some acts that are being amended by this bill will include the Indian Post Office Act 1898, Environment Protection Act 1986, Public Liability Insurance Act 1991, and the Information Technology Act 2000. Now let's look at the main key points of this bill. The first is, under this bill, several offences with an imprisonment term in certain acts has been decriminalized by imposing monetary penalty instead. So for example, under the Agriculture Produce Grading Marketing Act 1937, counterfeiting grade designation marks is punishable with imprisonment up to 3 years or up to fine of 5,000 rupees. The bill replaces this with penalty of 8 lakh rupees. So basically they are substituting the punishment to a monetary penalty. All right, and if we take another example, under Information and Technology Act 2000, disclosing personal information in breach of lawful contract is punishable with imprisonment of up to 3 years or fine up to 5 lakhs or both. The bill replaces this with a penalty of rupees 25 lakhs. And in certain acts, offences have been decriminalized by imposing a penalty instead of a fine. So for instance, under the Patents Act 1970, a person selling a falsely represented article as patented in India is subject to a fine up to rupees 1 lakh. The bill replaces the fine with a penalty which may be up to 10 lakh rupees. In a case of continuing claim, there shall be an additional of 1000 rupees per day. The second key provision of this particular bill is revision of fines and penalties. So the bill increases the fines and penalties for various offences in the specified acts. Further, these fines and penalties will be increased by 10% of the minimum amount every 3 years. Then lastly, the most important thing is appointing adjudicating officers. As per the bill, the central government may appoint one or more adjudicating officers for the purpose of determining the penalties. The adjudicating officers may summon individuals for evidence and can also conduct inquiries into violation of the respected act. Now these acts, if we see what all these acts are, there is Agriculture Produce Grading and Marketing Act 1937, Air Prevention and Control Pollution Act 1981, the Environment Protection Act 1986, and the Public Liability Insurance Act 1991. The bill also specifies the appellate mechanism for any person aggrieved by the order passed by an adjudicating officer. For instance, in the Environment Protection Act 1986, appeals may be filed with the National Green Tribunal within the 60 days from the order of the adjudicating officer. Now let's talk about the next bill, that is Repealing and Amending Bill. So this bill was introduced in Lok Sabha on December 19, 2022. It seeks to repeal 65 laws that are obsolete or that have become redundant by other laws. It also corrects minor drafting errors in Factoring Regulation Act 2011. So the main two things that this bill particularly talks about is repeal of laws. So the first schedule of the bill lists 24 laws that would be repealed under this particular bill, and of these 16 are amending acts and 2 are from before 1947. The next, repeal of appropriation acts. The second schedule of the bill lists 41 appropriation acts that would be repealed. These includes 18 appropriation act for the railways, and these acts span from the year 2013 and 2017. Alright, the next bill that was passed that we will be talking about is the Mediation Bill 2021. So the Mediation Bill was introduced in Rajya Sabha on December 2021. Before we get into much depth, let's just understand what exactly mediation is. Mediation is a form of alternative dispute redressal where parties attempt to settle their disputes outside court with the assistance of an independent third person who will be known as a mediator. Alright, now talking about the bill seeks to promote mediation, including online mediation, and provide for enforcement of settlement agreements resulting from mediation. Now talking about the key features of this bill, before we talk about that, let's just note here that this bill is giving us major provisions about the mediation as an alternative dispute resolution, as there has not been enough talks about it except certain mentions in different acts. So now let's talk about the applicability of the Mediation Bill. So Mediation Bill will apply to all mediation proceedings conducted in India where parties reside in India or are incorporated in India or have their place of businesses in India. The mediation agreement says that the mediation will be as per the bill. Thirdly, that there is an international mediation related to a commercial dispute where at least one party is a foreign government or a national, and the other entity is from India. Now in these cases, if the central government or the state government is a party, the bill will only apply to commercial disputes and other disputes as notified by the government. Now let's talk about pre-litigation mediation. So bill also provides for pre-litigation mediation in case of similar commercial disputes. A person must try to settle the dispute by mediation before approaching any court or certain tribunals as notified. Even if the parties fail to reach a settlement through pre-litigation mediation, the court or tribunal may at any stage of the proceeding refer the party to the mediation if they request for the same. Now let's talk about, according to the bill, there are certain disputes that do not fit for mediation. Now these will include disputes relating to claim against minors or persons of unsound mind, dispute involving prosecution of criminal offences, dispute affecting the disputes which are related to right of a third party, and disputes relating to levy and collection of taxes. The central government may amend this list of disputes, but as of now there are 4 main categories. Now these categories are dispute against minor or unsound person, a dispute involving prosecution for criminal offences, a dispute affecting the rights of a third party, and lastly dispute relating to levy or collection of taxes. Whereas this can be changed by the central government. Now let's talk about the mediation process as given in the bill. So mediation proceedings will be confidential according to the bill, and a party may withdraw from the mediation after the first 2 mediation sessions. The mediation process must be completed within 180 days. Even if the party fail to arrive at the agreement, it cannot be extended than more than 180 days, except when the parties have agreed that they want to extend it more than 180 days in case of court annexed mediation. So basically mediation conducted at a mediation center established by any court or tribunal. The process must be conducted in accordance with the directions and rules established by the Supreme Court or the High Court of that particular state. Now, who exactly are the mediators? So mediators is an independent third party, and according to the bill, the mediators will only assist the parties to settle their dispute but cannot impose a settlement on them. Mediators may be appointed by the parties by agreement. A mediation service provider, that is an institution that administers mediation as a process, and mediators must disclose any conflict of interest that may raise doubts in the mind of the parties of their independence, of their unbiasedness. Now talking about the Mediation Council of India. Now the bill provides that the central government will establish Mediation Council of India. The council will consist of a chairperson, 2 full-time members who will have experience in mediation or ADR, 3 ex officio members including secretaries of Ministry of Law, Justice and Finance, and 1 part-time member from an industry body. The functions of the Mediation Council of India would be registration of mediators and recognizing mediation services providers and mediation institutions, and then providing them with training, education and certifications. Now the next thing that we talk about is mediated settlement agreement. That this is another thing that is provided by the bill. So the agreements resulting from mediation, according to the bill, must be in writing, signed by the parties and authenticated by the mediator. Such agreements will be final and binding and enforceable in the manner as court judgments, except agreements arrived at after community mediation. So mediated settlement agreements, besides those arrived in the court referred mediation or by Lok Adalat or permanent Lok Adalat, may be challenged only on certain grounds, and these grounds are fraud, corruption, impersonation and relating to disputes fit for mediation. Now talking about community mediation may be attempted to resolve the disputes likely to affect the peace and harmony amongst the residents of a particular locality. It will be conducted by a panel of 3 mediators and which may include persons in the standing committee or representatives. Alright. And if we talk about this interface of this particular law of the mediation bill with other laws, the bill will override other laws on mediation except certain, and the bill also makes except certain which are given in Legal Services Authority Act 1987 and Industrial Relation Code 2020. The bill also makes consequential amendments in certain laws such as Indian Contract Act and the Arbitration and Conciliation Act 1996. The next bill that we will be discussing today is the Biological Diversity Bill 2021. This bill was introduced in Lok Sabha by the Minister of Environment, Forest and Climate Change, Mr. Bhupendra Yadav, on December 16, 2021. The bill amends the Biological Diversity Act 2002. The Act provides for the conservation of biological diversity, sustainable use of its components, and fair and equitable sharing of the benefits arising out of the use of biological resources. The current bill seeks to streamline research and patent application and encourages cultivation of wild medicinal plants and practice of indigenous medicine. Now let's talk about certain key amendments of the bill. So let's talk about the Act of 2002 first and then refer to what has been spoken in the bill. So according to the Act of 2002, which provides for the National Biodiversity Authority, which regulates access to biological resources and sharing of research results of such resources. Biological resources include plant, animals, microorganism or their genetic material with use or value of humanity. Now certain entities must seek approval from the NBA for obtaining biological resources before applying for IPR, that is intellectual property right. Now these entities are non-citizens, non-resident citizens, organizations not registered in India, and organizations registered in India with any non-Indian shareholding or management. The bill amends the last category to any foreign controlled company registered in India. It changes, the bill is amending only the last category here, which is any foreign controlled company registered in India. The bill also provides that these 4 categories of applicants must obtain NBA's approval before the grant of IPR. Now under the Act, state biodiversity boards are set up by state government to advise them on conservation of biodiversity. Indian citizens and organizations registered in India must give prior intimation to the concerned SBB, that is State Biodiversity Board, before obtaining any biological resource for commercial utilization. They must also get NBA's approval before applying for IPR. Now this was what was in the Act. Now what bill says? The bill amends this to provide that anyone who does not need approval from NBA to access biological resources must give prior intimation to the concerned state biodiversity boards. Alright, now let's talk about the exemptions. Now under the Act, certain communities are exempted from intimating the State Biodiversity Board before obtaining any biological resources for commercial utilization. Now these are the people who have the exemptions are local people and communities of that area and practitioners of indigenous medicines such like Vaids and Hakims. The bill extends the exemption to registered Ayush practitioners. So Ayush is Ayurveda, Yoga, Neuropathy, Unani, Siddha and Homeopathy. So the bill has given exemptions to Ayush practitioners and cultivated medicinal plants and their products. Now let's talk about the composition of National Biodiversity Authority. The Act of 2002 provides for 16 members in the National Biodiversity Authority, which includes 10 ex officio members appointed by the central government dealing with certain ministries such as biotechnology, agriculture, environment, forest, Indian system of medicines, earth sciences, etc. Secondly, there are 5 non-official members who are subject matter experts and representatives of industries. Now, what does the bill say now? The bill provides for additional 11 members. Now, these 11 members would include, so there were 16 members already. Now, there are additional 11 members which will be included by the bill. Now, out of these, there will be 6 ex officio members dealing with wildlife, forestry and Panchayati Raj, 4 representatives from state biodiversity board, 4 representative would be from state biodiversity board on a rotational basis, and a member secretary. So he must, the member secretary must have experience in biodiversity conservation. The member secretary will be the chief coordinating officer of the NBA. So this bill, if we can see, it seeks to amend a little bit like the composition of National Biodiversity Authority. There were 16 members originally, additional 11 members have been added. Now the bill also amends certain things about the threatened species. Now let's see what does the act exactly says. The Act of 2002, what it says, the act basically empowered the central government to notify any species which is near extinction as a threatened species in consultation with the concerned state government. Now the bill allows the central government to delegate this power to the state government itself. So now the state government can notify any species which is near extinction as a threatened species. However, before notifying any of these species, the state must consult the National Biodiversity Authority. Now talking about the next thing, that is Biodiversity Management Committee. So this committee, the act mandates that local bodies to constitute a BMC, that is Biodiversity Management Committee, for promoting and conservation of habitats and documenting the conservation of specific plants, varieties, animal breeds and microorganisms. The bill specifies that the state government will prescribe the composition of these biodiversity management committees, and they must have between 7 to 11 members in these committees. And further, the state government may also constitute biodiversity management committee at intermediate and district panchayat level as well. Now let's see the next bill, that is the Cinematographer Amendment Bill 2023. So the Cinematographer Amendment Bill was introduced in the Rajya Sabha on July 20, 2023, and the bill amends the Cinematographer Act 1952. The Act constitutes the Board of Film Certification for certifying film for exhibition. Such certification may be subject to modification and deletions, and the board may also refuse the exhibition of certain kinds of films. So this is what Cinematograph Act 1952 provides for. Now talking about the amendments that the bill suggests, it talks about additional certificate categories. So the bill adds certain additional certificate categories based on age. Under the act, film may be so this is under the 1952 act, the films were certified or classified as without restriction with the U letter, without restriction but subject to guidance of parents or guardians for children below the age of 12, that is UA, and only adults, that is demarked with an A, and only to members of any profession or class of persons, which was marked by S. Now the bill substitutes the UA with following three categories. Now these three categories are UA 7 plus, UA 13 plus and UA 16 plus. Now these are depending on the age. The age endorsement within the UA category by the board will inform guidance of the parents or guardians and will not be enforceable by any other person other than parent or guardian. Now the bill also talks about separate certificate for television and other media. Films with an A or S will require a separate certificate for exhibition on television. So the films that are written with U or UA will not require a different certificate, whereas the films which are marked with A and S, so films meant for a certain profession or films only for adults, will require a separate certificate for exhibition on television or any other media prescribed by the central government. The board may direct the applicant to carry an appropriate deletions or modifications for the separate certificate. Now about the unauthorized, the bill also talks about unauthorized recording, and it says that unauthorized recordings and exhibition will be punishable. The bill prohibits carrying out or abetting the unauthorized recording and unauthorized exhibition of the film Attempting an unauthorized recording will also be an offense, and an unauthorized recording, basically an unauthorized recording means making or transmitting an infringing copy of a film at a licensed place for film exhibition without the owner's authorization. So basically, when certain people record the movies in movie theaters, those would be called unauthorized recordings. An unauthorized exhibition means public exhibition of an infringing copy. So basically, you are showing it to people, but the copy that you are showing is an infringed copy. Alright. At a location which is not licensed, other scenarios that this particular copy is being shown at a location which is not authorized to exhibit films, or in a manner that it infringes copyright law. Alright. Now, there are certain exemptions which are given here. So, these exemptions are basically under the Copyright Act 1957, which will apply to the above offences. So, according to the Copyright Act 1957, it allows limited use of copyrighted content without owner's authorization, and there are certain circumstances also. One would be that it was for a private or a personal use, or while you were reporting current affairs, or you were trying to review or critique the work. In these certain circumstances, you can you can use the copyrighted material, but the above offences will be punishable with an imprisonment between 3 months and 3 years with a fine of rupees 3 lakhs and 5% of the audited gross production cost of this particular copyrighted of the infringed material. Alright. Now, earlier if we see that the certificate under which were given for the movies under this act which were issued were only valid for 10 years, but now the bill provides that the certificates will be perpetually valid. And lastly, the revisional powers of the central government. The act empowers the central government to examine and make orders in relation to the films that have been certified or are pending certification. The board is required to dispose matters in conformance with that particular order that has been given by the central government. Now, this was what was given in the act. What bill does? The bill is removing this power of the central government. So now the central government does not have the power to examine and make orders in relation to the films which have gotten certificate or are pending certification. So I think this is it from our side today. I hope this video has given you a better understanding of the important legislations that were enacted during this monsoon session. For more such video, keep watching Pratham Test Prep, and thank you so much for watching. If you like the content, please like, comment and share, and do not forget to subscribe to the channel. Thank you. Have a great day ahead.